use of the wires in a scheme to defraud. That's the wire fraud statute. The mail fraud statute is use of the mails in a scheme to defraud. So the basic idea with wire or mail is that the wire transmission or the mailing confer federal jurisdiction that allows them to prosecute the underlying fraud scheme. And that's what it is. So for example, in a mail fraud case, they might prove up a fraud that someone defrauded a company or somebody else, and they would prove a mailing. And that's the way that the federal court has jurisdiction. The mailing doesn't really have to have anything to do with the fraud. It doesn't have to be done by the person accused of the fraud. It just has to be something that occurred in the course of events that confers upon the federal court jurisdiction. That's all it is. Well, I tried my first mail fraud case as co-counsel with Ron Meshbecher in November of 1984, and I've tried many wire and mail fraud cases in the 36 years since then and handled many more. It's a very common federal crime. It's a crime that prosecutors like to charge because the statutes are easy to work with and the juries can understand mailing something or sending an email or something like that. So I do lots and lots of federal white collar stuff, and those are two of the generally used statutes. The other one is bank fraud. The prosecutors like bank fraud because it has a 10-year statute of limitations as opposed to 5 years for mail and wire fraud. So it allows them to reach back further. So